Hi, I'm Mark Schroeder from GSHC Surrogacy Agency, and today we're speaking with David Cole to talk to him about the legal aspects of surrogacy in Texas. David, how are you doing today?
I'm doing great, Mark. How are you?
Doing very well. Thanks for asking. First question, what does a surrogacy attorney do?
Thanks for the question, Mark. A surrogacy attorney primarily first is going to orient the intended parents and sometimes the gestational surrogate to the legal aspects of gestational surrogacy. So what that means is initially making sure everybody understands what the process looks like. So in Texas, that's going to be preparation of a gestational agreement, which is going to provide that the intended parents are parents of the child that is carried by the gestational surrogate. And then it's also going to include the establishment of the intended parents as legal parents pursuant to the Texas Family Code. So we like to say it's really a kind of a three-step process. We have an orientation process just to make sure everybody understands sort of the way it works. We then are going to do a gestational agreement, which is going to provide for the parameters of the relationship between the intended parents and the gestational surrogate. And then there's a legal process, which is typically started after we have a pregnancy, which would establish parentage, formal parentage in the intended parents. And that legal process is what creates the Texas birth certificate.
And can you explain what a surrogacy contract is and why that's important?
In Texas, we call it a gestational agreement. A gestational agreement is the agreement that's entered into between the intended parents and the gestational surrogate. The gestational surrogate's husband, if she's married, would also be a party to the agreement. The agreement provides, first and foremost, that the child that she is carrying would be the legal child of the intended parents. The agreement will also provide for her financial protection through the process. Her base rate compensation, sort of the what ifs financially, like what if she has an extended bed rest or had some other invasive procedure. And then the agreement also provides for how to make a decision. How will the parties make a decision? If there were a situation where the child had some sort of fetal or congenital abnormality and the intended parents were requesting a decision or requesting that she terminate, the agreement has adequately worked through how we're going to make that decision.
Do intended parents need to provide health insurance for their surrogate?
There are intended parents who will, like let's say we do a verification of the gestational surrogate's health insurance and it shows that the insurance will not cover pregnancy-related expenses incurred by a gestational surrogate. Then the intended parents have a couple of options. One option is that they purchase a health insurance policy for the gestational surrogate. There are brokers like Art Risk, New Life, some insurance brokers that will sell those policies. Those policies typically are pretty expensive if you're buying a health insurance policy with the intention of becoming pregnant. But there are policies. Another option would be that you wait until open enrollment for the Affordable Care Act. And then at open enrollment, we have the gestational surrogate apply for a policy. Those policies that are on the ACA website tend to cover gestational surrogacy. And then the third option would be that the intended parents do some sort of combination of private pay plus maybe some sort of catastrophic medical complications policy, where maybe they're buying a complications policy that's not going to kick in until they hit a certain point in expenses, which might be something very high, like $25,000. And then they would pay for the pregnancy-related expenses that come in under the $25,000, they would just pay out of pocket. So there are very good organizations out there like Art Risk that specialize in this and can really help intended parents with this sort of decision making.
And David, what happens if the surrogate suffers complications during the pregnancy?
There are a number of things that could happen during a pregnancy medically that we may need to think about at the point of drafting the agreement. So for instance, if a surrogate were to have, let's say, an extended bed rest at some point during the pregnancy, then the agreement needs to provide for how she's going to be protected financially during that period, and how she's going to be able to maneuver through just the ordinary decision-making that she has to make in her household. The goal here is that she deliver a healthy child. So we want to set up, from the intended parent standpoint, you want to have an agreement that is going to adequately protect that process. The process of her being able to successfully maneuver through a pregnancy and deliver a healthy child. And if she has a complication, we want the agreement to provide for how that's going to happen. The goal is to have an agreement that's going to adequately provide for how to answer all these questions.
This has been a conversation with attorney David Cole. David, thank you so much for your time today.
Mark, thank you. I enjoyed it. And we're a law practice in Dallas, Texas. You can find us at www.artslegal.com. Thanks very much.